very good morning to all of you. I am Esha, your host this morning. I extend a very warm welcome to all of you from all of us here at Areness, which is a consulting and advisory firm with over a decade of experience serving corporate clients. Over the years, we have consistently delivered top-notch business advisory services and practical solutions backed by in-depth research to clients worldwide. Our team of in-house experts takes great pride in offering unparalleled and diverse solutions to our valued clients spread across varied domains like fintech, banking, technology, cosmetics, F&B, government organizations, and so on. Our core strength is our expertise in practice areas like cyber law, insolvency and bankruptcy, BFSI, corporate governance, general corporate, public policy, intellectual property rights, and dispute resolution, to name a few. Today, I am thrilled to introduce to you Statusphere, an exclusive webinar series by Areness in association with ARM Worldwide and Girma Pro. ARM Worldwide is a digital marketing communications agency forging close alliances with businesses and guiding them towards a transformative mindset that unleashes their potential to grow and establish sustainable competitive advantages and creating a positive societal impact. While on the other hand, Girma Pro has been an instrumental boutique in reshaping the organizations through various strategic HR consulting services like empowering organizations and driving their success with services like recruitment, payroll management, background verification, employee secondment, labor law advisory, and much more. Thank you, ARM Worldwide and Girma Pro, for being a part of this webinar series that has been so thoughtfully curated by our corporate professionals and for the corporate professionals to empower them with the knowledge and tools necessary to navigate the complex legal landscape effectively and thereby mitigating risk and safeguarding their operations. In today's session, we will be diving deep into a very critical topic, the protection of digital personal data with specific focus on DPDP Act 2023, compliance for fiduciary. I'm honored to have amongst us today Mr. Rajeev Ranjan Shahi and Ms. Shreya Jeet to share their insights on this topic. And I obviously thank you all for joining us today. So let's get to know our experts a little more before we dive deep into the session. With us, we have today Mr. Rajeev Ranjan Shahi, who is an associate partner here with us at Areness. He is a dynamic legal professional with expertise in data protection, privacy, tech law, and has a unique blend of legal expertise and technological acumen. With a rich experience in legal advisory services, he brings a wealth of expertise in cyber law, privacy law, intellectual property rights, and his impressive portfolio includes servicing as a legal advisor to esteemed entities such as Microsoft Corporation India Private Limited, Ministry of Electronic and Information Technology, GOI, National Biodiversity Authority, amongst others. He has been an instrumental part in spearheading legal operations, handling contract management, litigation management, legal compliance, dispute resolution, legal advisement, and corporate governance. His proficiency extends to resolving consumer and e-commerce disputes, showcasing his prowess in mediating complex matters and safeguarding consumer rights. Holding a LLB degree and an MS in Cyber Laws and Information Security from the esteemed IIIT, Mr. Rajeev stands at the forefront of intersection between law and technology. His commitment to justice, coupled with his comprehensive educational background, sets him apart as a visionary in the legal field. Once again, a very warm welcome to you, Rajeev ji. We really wish to thank you for taking out your precious time today to share your insights on this valuable and, very critical topic. And we also have with us Ms. Shreya Jeet. She is a public policy lead here at Areness. Being an expert in public policy, aviation law, sports law, and environmental law, Ms. Shreya is a deeply committed personnel, in devising growth strategies and crafting legal solutions based on global best practices. She has previously served as a consultant to government dignitaries and has been mentored by diplomats like Mr. K.P. Fabian. She has also worked with governments of Bengal, Kashmir, and Maharashtra. Her visionary approach evolves in harnessing technology to provide sustainable long-term legal solutions. Moreover, her diverse portfolio includes working as a legal consultant for industry experts like Future Generali, Ogilvy, Wunderman and Thompson, IPAC, ASAP Kerala, and Bombay Port Trust with a clientele spanning national and international domains. Having excelled academically with the best academic institutes in the country with dual degree in LLB and international law and diplomacy, she possesses a comprehensive understanding of the international obligations and commitments of Government of India concerning various bilateral, multilateral treaties and dispute resolution mechanisms, as we are privileged to have Shreya amongst us today. And we really extend a very warm welcome to you. Thank you for being here. And diving deep into the agenda for today's hour, for the next 1 hour, they will be covering various aspects of compliance of Data Fiduciary Act under the DPDP Act 2023. For any questions during the presentation, we request you all to type them into the chat box and we'll ensure to cover as many questions as possible at the end of the session. Now I request Ms. Shreya to set the tone for the session and throw some light on the DPDP Act. Over to you, Ms. Shreya.
Thank you so much, Asha, for such a kind introduction. So when we speak of Digital Personal Data Protection Act, the much-awaited DPDP Act 2023 came into force on August 11 this year. It's primarily meant to safeguard the rights and the duties related to the management of massive digital personal data accumulating in the economy. And when I speak of Indian economy, I also speak for the 140 billion Indians that we speak of. The widespread use of information, communication, and the technology has led to creation of digital data, which, if explored, could be a valuable means for business transformation. There is every effort by market players, be it international or national, to access these data and make use of it to identify opportunities. It is well fitted that such an act comes into picture. So it was in 2025 that IDC Projects did a study and said the total size of data generated worldwide could reach to 175 trillion zettabytes. In India, the digital population reached close to 700 million active internet users, with 467 million social media users creating mammoth digital data. As a result, India has become the second largest internet market. It's right to say that digital data has also emerged as an all-pervasive business enabler, be it its generation, ownership, sharing, data protection, and maintenance of mutual trust among data transmitters who assume great significance. Often we hear the term data is the new oil, data is the new oil, but when we look into the history, when we trace its roots, it was actually a British mathematician, Mr. Clive Humphrey, who in 2006 said and visualized the importance of data and said that data is a new oil. Digital data has become a precious tradable commodity that can potentially be a competitive leverage for marketplace and also a threat to a country like India. And when we speak of India, we also speak of Indian subcontinent because we set the tone of our neighboring countries where we are seen as a big brother. So, yes.
That was very insightful, Ms. Shreya, and I totally agree with you. And now I'd like to invite Mr. Rajeev to elaborate on the key players in the regulation and jurisdiction.
Thank you so much, Isha, and also thanks, Shreya. So for you elaborate importance of data in context of Indian jurisdiction. And we would like to here understand, who is a player under this act exactly, because everything is defined under this act in forms of rights and duties. So In this act, there are 4 types of key players. The one is data principal, is talking about the natural person to whom whatever we are talking about right now in terms of protection of their privacy, and data fiduciary, who hold the data of the natural person for the particular objective. And data processor is the entity who act under the control of data fiduciary. And consent manager is an entity who is a act in between the data fiduciary and data principal. He is acting as a stand with the help of one example. Suppose the bank is going to offer a loan. So bank would be treated as a data fiduciary and customer would be treated as a data principal. So both have a direct contact between this data principal and data fiduciary. And data processor, suppose bank is going to take a lot of processing activities. Maybe he's going to take this data on the cloud service form, and maybe he's going to take some other activities in terms of verification. Then he will be take as a data processor. And consent manager is just like acting as an attorney. Means he is just taking a proper consent from the data principal to the data processor. And it is very important to understand applicability of act. The jurisdiction, in the very layman language, we can say where this act will be applied. So for that, we have to understand 2 aspects: one subject matter, other one territorial. So subject matter, I would like to read a direct provision. The act applies to the personal data that is collected in digital form. So right now we are talking about in the context of 0 and 1 with respect to the digital context exactly. Suppose any information is available in the 0 and 1, or we can say in the technical way is digital format, then it will be applicable. And other would be non-digital form, maybe physical form, but consequently it was converted in the digital form. So here I would like to give you some examples. Suppose the bank is taking some information from the data subject in some information as a physical copy, and after that this physical copy is converted in the soft copy, a digital format. Then this will be applied. Jurisdiction, because it is a sovereign law, it should be applicable throughout the India, and it will also applicable outside of the India if any entity is offering a service of the residents of Indian. Then this act will be also applied.
Perfect. Thank you, Mr. Rajeev, for shedding light on this critical aspect. But still, I'd like to understand how and why the data privacy aspect came into existence.
Yes, Asha. So speaking from public policy point of view, when we speak of Justice Puttaswamy judgment, well, in August 2017, it was a 9-judge bench of the Supreme Court, and Justice K. Puttaswamy, who was a retired judge, versus Union of India. In this judgment, it unanimously held that Indians have a constitutionally protected fundamental right to privacy that is an intrinsic part of life and liberty under Article 21. As we know, all rights emerge from natural right, and it held that privacy is a natural right, which is inherited by all natural persons, and that the right may be restricted only by state action that passes each of the 3 tests. Now, there were 3 tests which was given. Number 1 was that such state action must have a legislative mandate. Number 2, it was that it must be pursuing a legitimate state purpose. And number 3, it said that it must be proportionate. Such state action, both in its nature and extent, must be proportionate to its justification. And it should be necessary in a democratic society, and the action need not be least intrusive of the available alternatives to accomplish the ends. So privacy judgment was considered as a guiding tool, and we still consider it as a guiding tool because as a landmark judgment, it did not just fundamentally change the way in which the government viewed its citizens, be it their privacy or both in practice and prescription, but also it requires government and even private bodies to undertake structural reforms and bring transparency and openness in the process of commissioning and executing its surveillance, be it with regards to projects, schemes, build a mechanism of judicial oversight over surveillance requests. It demands from the authorities to demonstrate great care and sensitivity in dealing with personal information of its citizens. It also requires a legislative, transformative, right-oriented data protection law, which just came, on August 11, which will hold all powerful entities that deal with citizens' personal data accountable, which will also include the state. Now, what steps have been taken with this regard to strengthen privacy regime? As we know, data protection bill was introduced in 2018 as per the recommendation of B.N. Sri Krishna committee report, and the same was taken as a law and brought into a law on August 11, 2023. That report of B.N. Sri Krishna committee had a wide range of recommendations to strengthen privacy law in India. Its proposal included restriction on processing and collection of data. It said data protection authority has to be created, which will have the right to be forgotten. So if a data has been collected, it will also be removed. There will be a right to forgotten. There will be no digital footprint unless until a person consents about it. There will be data localization, say data is originated in India, it will go by the sovereign rule of being locally stored. Then explicit consent requirement for sensitive personal data. Information Technology Act of 2000, which is the IT Act, also provides for safeguard against such breach in relation to data from computer systems. It contains provisions to prevent the unauthorized use of computers, computer systems, and data stored therein. Then, what happens when we speak of K.S. Puttaswamy, we also speak that there has been little change in terms of narrative that local people, as citizens that we have in our head, we are still very careless when we are giving out the data. We are not as particular as, other countries with other developed countries, I would say, who practice these, these regular, systematic way of data assimilation. Now, there may be various aspects with regards to national security versus privacy, which comes into light. I would also say that Ministry of Home Affairs in December 2018 authorized 10 central agencies to intercept, monitor, and decrypt any information which generated, transmitted, received, or stored in any computer in the country. So even before the law came into pictures, there were safeguards which were being taken, into action at the government level, because it is an important aspect. In July, again, the same year, 2018, it also became to be known that Ministry of Information Broadcasting had floated a tender for social media monitoring hub. So now that the law comes for us as citizenry, but with regards to institutions, there were safeguards which were made. And this was only because of B.N. Sri Krishna Committee report and K.S. Puttaswamy judgment. So, yes.
Perfect. I think that sounds right. So to Mr. Rajeev, my question would be, what is personal data?
Yeah, thank you so much, Isha. And also, I would like to thanks to Shreya, because she elaborate this entire privacy law with respect to the fundamental right. It's very elaborate, and we need to understand right now in terms of this particular act. So whatever Shreya has discussed about the importance of the Puttaswamy judgment and other committees report of this particular aspect, right now everything has been translated in this particular act in forms of rights and duty. So first we need to understand what acts is talk about the personal data. So I would like to read the direct provision. The personal data means any data about an individual who is identifiable or by in relation to such data. And data is already been defined in this act in the very very conceptual manner. So we would try to understand what is the meaning of personal data in context of nature of information. So nature of information may be the objective, maybe the subjective. Suppose if I would like to give an example, the particular email ID, a physical address would be identified very easily, because it is very objective test. If we want to understand in context of opinion, suppose one person working in organization for the long time, and the HR team has some opinion about his performance, then we have to take a context about entire this, opinion with respect to the particular person, and that will be also treated as a personal information. And content is a similar, like just like if you have a content with respect to the any anything. So here I would like to give example. Suppose I am working as a doctor, and I communicated my opinion to my customer. So customer is an individual person. So definitely I'm communicating through the email. So the email and my email would be treated as a, very objectively. But if I am giving an opinion of with respect to the health, and tomorrow something is, there is some legal dispute with respect to the medical negligence. So maybe this my content would be, treated as a, personal information with respect to the patient. And format means format, and we know because this information is existing in the different format, maybe some hard copy. Sometimes we have it, information is located on the virtual world, some cloud service provider. So in context, we would take a reference about the personal data. We have a lot of examples, just email, phone number, existing customers, physical address, photograph, genetic, mental, economic, cultural, and health, etc. And please come on the next slide. Team member is not here. Okay, so Isha, are you able to manage this next slide?
I don't have access. I'll just check with the team. Just give me a minute. And in the meanwhile, if you could address what data protection
I'm going to explain exactly, So what is meaning of the protection? Because so far we have already, make our sense about what is meaning of the personal data. And we will try to understand what is meaning of the protection with context of personal data. So this act is talks about in the two way. The one way is that is giving instrument to individual. They can manage their information in a very absolute manner. They have absolute power. And the second aspect would be as a form of duty to data fiduciary. They can follow some duty, because as we know, whenever data fiduciary is processing information of individual, they need to follow a lot of activities. They are sometimes they're organizing the information. Sometimes they are, this information is locating on the other service provider. So these activities is need to follow some duties exactly. Duty in forms of how, why, or when, and what is the manner exactly. And this manner need to be, controlled by the data principle in forms of proper communication, in forms of the contract. The spirit of this, particular PPT is that means I would like to say data principle has instrument, they can manage information in terms of proper communication. Data fiduciary obviously is going to execute his particular objective. But what manner is going to execute his particular objective? This objective need to be apprised to data principle. This is the form of control exactly.
Perfect. So basically, so far we've understood that majority of companies providing services indeed fall under the definition of data fiduciary, correct? And could you shed light on who constitutes a significant data fiduciary under the Act?
Yeah, it's very important, aspect. We need to understand as per the direct provision, what is the meaning of data fiduciary. So Data fiduciary means any person. Yes, I would like to give a little bit, attention, some underline point here. Data fiduciary means any person who alone or in conjunction with other person determines the purposes and means of processing of the personal data. So any person is talking about natural persons, maybe artificial person, maybe government agency, maybe whatever exactly. It's very exhaustive list, okay. And conjunction with the other persons, maybe because we have already, tried to understood in context of the bank, so because bank is going to provide a loan to individual, okay. So he is a entity, is a person who is going to decide what is the objective, means provide the loan, okay. This is one underlying point. And what is the way, how is going to process this entire data exactly, So this would be decided by the person who are going to provide the services. So here is, I would like to say there are three elements. One element is a person, means data fiduciary, if you can understand exactly. Maybe natural persons, maybe artificial person. Other means taking a decision in terms of deciding whether he's going to execute this particular objective or not. This is a different thing. And how is going to the process the information. This is very important underlying point here, because this act is talking about to the distal and the distal sense exactly. Because if I am the customer, I am providing my some information to the bank for a loan. So this my information in forms of digital would be treated as a as a personal information, and this personal information is how is going to execute, what is the process exactly. That is the element of this particular definition. So we have a lot of examples. Suppose whenever this, we have a lot of list, very exhaustive list. Suppose I would like to take example of insurance sector. Okay, if insurance sector is going to execute their, this particular duty in terms of providing some insurance to the customer, maybe is going to the follow in terms of processing, how is going to the process the particular information, what would be the particular mechanism. This mechanism has been regulated under this act. If he's going to follow this mechanism in terms of processing information, how is going to the process this information, that is the part of regulation. And then this entity will become under the scope of definition of data fiduciary. At the same time, we need to understand here what is meaning of significant data fiduciary. It is a very specific bracket. This bracket is quite sensitive nature, because this bracket has a different type obligation, some additional obligation. Means this bracket is also data fiduciary, but due to some particular sensitive activities, he need to follow different type compliance part. So the act is talking about the significant data fiduciary, means data fiduciary, a class of data fiduciary are may be notified by the central government. So far, there is no notifications. Maybe within the 2 months or 3 months, we will get some notification regarding this particular aspect. And what would be the criteria? What would be the criteria? How government is going to decide? So deciding factor would be the following: the volume and sensitivity of the personal data processed, risk to the right of data principle, potential impact of sovereignty and integrity of India, risk electoral democracy, security of state and public order. So as we know, because this underlying point is having different type understanding, having different type connotation. That is just this entire thing is put in the different bracket in terms of compliance.
Perfect. So this is indeed very valuable information about data fiduciaries. Could you please also elaborate on the legal obligations of a data fiduciary, and are there any additional obligations for a significant data fiduciary as per the Act?
Yeah, because he has to appoint a data protection officer, and their compliance mechanism would be very strong. This is the additional obligations as per the Act is right now. Maybe we will get some specific rules with regard to this particular aspect, then we can understand. Please get on. Next slide. Yeah. So it's very important, aspect. Yeah, could you please refer? Yes. So yeah, I'm very sorry because there was some, uh, technical problem. So
no worries at all,
yeah.
sir.
So we are talking about, compliance aspect, in terms of duty exactly, the data fiduciary obligations. So we need to understand, what is compliance has been imposed on the data fiduciary. So we would try to understand in the three way. One would be the general, and the second would be the special, and third one is the technical exactly. So what acts talk about in context of general? They process the personal data as per the provision of Act. So if you would go to the entire Act, they're talking about how, when, and why. If you're processing any information on the virtual world, so you need to apprise this fact to data subject. It should be, it should be proper communication. And what is the lawful purpose? So lawful purpose Act also says about an act, particular act and activity which is not prohibited by law would be treated as a lawful purpose. So here we have to understand negative definition exactly. If something is suppose if I would like to give example of the PMLA Act, okay, Money Laundering Act, and if any individual is providing information for this particular activities, so as no this act has been prohibited by the particular act. So it may be this particular aspect will be not a protected under this act. And other would be the ensured the individuals are informed by the notice. It is very important because, so far we are trying to make a sense how this entire exercise is going to happen through the proper notice. There is contact between the data subject and data fiduciary. And notice exactly. Suppose that how, why, or when he's executing anything would be communicated, channelized through the notice to the data subject. And the other element is talking about the same exactly, means it should be, properly communicated about to the any activities has been taken by the data fiduciary. And it is also very important to understand in terms of accuracy and completeness of the data, because as we know, so many service provider has been, doing a lot of activities. So for that, they have a different type, compliance, which regulated by the different type act. So suppose the bank sector, suppose bank is going to provide a loan to the natural persons, they need to check a lot of, information, whether this information is correct or not. Because sometimes, as you know, because just I'm customer, suppose that I'm approaching to the bank, I'm residing the particular address. Maybe my address will get changed after some time. So this thing will be, followed by the data fiduciary in the very, very sincere way. And as we have already discussed about at the outset, there are four type, key player exactly: the data subject and data fiduciary and data processor. So data processor, we have already discussed about data processor is, working under the instruction of data fiduciary. Suppose bank. So bank is, while providing a loan, he need to do a lot of activities in terms of maybe is going to put this information on the particular cloud service provider. Maybe he's going to take some service from the vendor who will do some verification check. So, here data fiduciary need to follow a lot of multiple activities with the help of different vendor. But this act is talking about whatever contract has been executed between the data subject and data principal, the same split would be communicated to the different vendor. Maybe he will be responsible for he will be responsible for the data fiduciary. But we are talking about this entire exercise in the digital ecosystem. So we need to understand. Maybe suppose I am just providing my information to the bank. Okay, this is my information, my address, my economic condition, so many things exactly. And this information has been verified by the different vendor on behalf of data fiduciary. Because this information is also going to this vendor exactly. So they need to also follow a lot of duties, which is per se applicable on the data fiduciary. And special condition, I would like to say it is also very different type bracket, in terms of compliance with respect to the child exactly. Because as we know, child is a very, special type class. So for that, they need to take a specific, verifiable consent from the guardian. And other would be, I would like to say, he need also check whether this information would be not a for behavior or some, conduct of the children, because it's going to decide a negative impact on the children. So this is the main factor. And as we know, this is also additional obligations for the appointing a data protection officer, because maybe this particular bracket would come under the definition of the special class. And technical would be, I would like to say, it's terms of preserving the information which would be not a compromise, because this information existing in the techno ecosystem. Okay, for that they need to deploy some technical aspect. It is not something contractual exactly. So maybe we would do some reasonable check whether policy is very strong or not. Maybe build a reasonable security safeguard to prevent the data breach. And it is also need to do some privacy by design. So privacy by design means here, when data is the part of this digital ecosystem, when because data is processing in the very multiple way, so then the service provider need to deploy some technical aspect at the every stage level in terms of policy. So if you're going to deploy the policy, maybe it will be prevent for the unauthorized access to the personal information. This is the sort of privacy by design. And information, the Data Protection Board of India affected persons to event of breach. So it is a very significant aspect in terms of duty, which need to be followed by every stakeholder, because there is data breach. So suppose if any data breaches happen, so data fiduciary would immediately apprise to board. And as we know, the 72-hour obligation is imposed under the certain. Maybe this obligation will be regulated by these specific rules. So definitely, I would like to say the certain whatever certain have notified with respect to the data breach, and the proposed rule will be regulated by this particular spirit of certain guideline. And it is the personal data as soon as the purpose has been made. So suppose if I'm providing my information to bank for the loan, a bank has already, sanctioned my loan, and I have already paid my loan to the bank. So maybe this entire thing is complete. If there is no otherwise legal, because as we know, so many law have different type implications on the such service provider. They need to maintain for the data for the particular period. If there is no otherwise implication, then immediately they need to erase the data.
Perfect. Thank you, Mr. Rajeev. Could you also provide some insight into what the Act stipulates regarding data breaches and outline any specific compliance requirements mentioned within the Act?
Yeah. Next slide, please. So, yeah, thank you so much, because, we have discussed about what is a duty in terms of technical aspect. And we need to understand what this Act is talking about, the data breach. Okay, so data breach means unauthorized processing of the personal data or accidental disclosure, acquisition, sharing, use, alteration, destruction, or loss of access to personal data that compromise the confidentiality, integrity, and availability of the personal data. So, here there are two type of obligation. One is controlled by the contract mechanism. Second would be in terms of deploy the technical aspect to the ecosystem of the service provider. So if we're going to deploy this, proper mechanism, proper, things, maybe it will be not this information will not get a compromise. This is the spirit of the particular, breach exactly. So breach means unauthorized processing means, suppose if I am providing information to the bank, he don't have a right to pass my information to the other entity unless I will not give a proper consent.
Mr. Rajeev, if you could also sort of take
Yes,
us
yeah,
through
it is a very, yes.
preventive measures.
Yeah. So, we are trying to understand in context of what is duty in terms of securing a digital information in digital ecosystem. For that, we have some duties. For that, the Act also suggested you should, do some proper activities, just like maybe you follow some ISMS. So in this information security management system is talk about how you are going to bring some policy, some tool, some mechanism, thereby you can maintain, confidentiality, integrity, and availability of the information. So if you go to the entire, this list means ISMS, a data impact assessment, and internal policy, and internal ITRD, and develop other preventive measures, have the same spirit. Means they're talking about policy, tools, mechanism, thereby you can, this maintain the three aspect of technology preventive, So could be this is the, maintain your information secure, and thereby you cannot any opportunity to compromise this information. And pseudonymize is also one mechanism, because as we know, if you are going to detach some element with respect to the individual information, thereby you are also mitigating the risk. So it is also sort of one mechanism, But these particular things will still come under the definition of the personal data.
Perfect. Thank you, Mr. Rajeev. And I request our audience to throw in their questions in the chat box. Whenever they want to ask something, we'll be addressing them at the end of our session. And now I would like to invite Ms. Shreya. Can you please explain the role and importance and responsibilities of a consent manager under this act? Ms. Shreya, I think you're on mute. We cannot.
So sorry. I
No
hope I'm
worries.
audible now.
Yes, you are.
Thank you so much, Asha, for the question. So, when we speak of consent, consent is the foundation for privacy protection and individual autonomy in the data privacy framework. As a word, what does consent means? It means someone agrees to something. Now that access, when it's given, it can be tangible or it can be intangible. So when we speak of data, it holds the same importance, right? Now, DDP Act is no different than IPC. There is, when we speak of consent, there are various ways it can be taken into picture, but yes, consent holds a immense importance. So consent manager, who is he? Now, clause 3, subclause 2 of the Act defines consent manager as a data fiduciary, which enables the data principal to give, withdraw, review, and manage his consent through an accessible, transparent, and interoperable platform. Now, India is an incredibly diverse nation. Thereby, operationalizing effective consent would need more than legal and regulatory controls. Under the Act, consent managers are third-party entities that will digitally enable consent through an interoperable technology framework. Also, please know that India will be the only country to statutorily recognize and adopt a tripartite model for data sharing. So, a data principal, a consent manager, data fiduciary will all act one and together. So let's just take a recent example. 2021, it was RBI which launched, the data fiduciary, which will enable this whole concept under account aggregators. So they launched to facilitate the consented transfer of financial data between regulated financial entities like banks, insurance companies, pension funds, etc. The account aggregators, which was started by RBI in 2021, were approved independent entities who were tasked to obtain, to submit, and manage customers' consent through a technical framework that incorporates legal principles for consented sharing. In essence, they were the consent managers in the financial sector and were referred to in the, like how in the current act we are mentioning consent managers under clause 3, subclause 2. So now when we speak of the genesis and the importance of consent manager framework, it was India's decision to adopt a fiduciary approach to privacy protection as per the Sri Krishna Committee recommendation, which I did mention, before when I spoke before. It said that it is very evident in the objectives and provision of the Sri Krishna bill, recommendation which was taken into data privacy bill. It said that one needs to make an effort to establish the concept of trust, and that trust will only be enabled when there's a person who is a licensed authority, so trusted by the entities, but also a person who will be trusted by the users, the data principals. So with rights and imposed obligation and being a licensed authority, consent managers hold a lot of responsible role in this whole framework. Now, as consent managers under the Act, they are independent entities. Okay, and they're entrusted to manage data subjects, consent for sharing data through an interoperable, secure, and transparent platform. They will be regulated by the Data Protection Authority, and they will operate within the paradigms of the electronic consent framework established by MeitY, which is Ministry of Electronics and Information Technology. MeitY has also released a set of technology standard for such electronic consent. Now, how would these consent managers work? So there are 3 participating entities within the consent manager framework. One is an information provider, who are the original custodians of the data. These entities will collect and store the individual's data. Now, the second is information users. They are the entities who will require the data from the data subject for providing certain services. And finally, the consent manager, the most important role, will be the entities licensed by the authorities to facilitate consent for sharing data. All three will operate over a common network, which will be based on specifications provided by the authority and Ministry of Electronics, Information and Technology. The application will be created, which will program interfaces, will be developed to connect to the network. The government will impanel independent certifying agencies to confirm compliance with, with the required standard for all the participants. Once the consent manager system becomes operational, the following steps must be taken to ensure compliance, and that will be, with regards to how they will be selected, how the information user will provide information, how the services they want to see it, what kind of services they'll be giving the information to. And once chosen, the information user will send an electronic data transfer request to the consent manager to fulfill the service request. Now, these are the technical aspect. We are still looking for a complete rule book on the same. But nonetheless, when we speak of banking sector, blockchain technology is being used heavily for data localization, data protection, and at the same time data assimilation. And the role of account aggregators, as mentioned, for the RBI, which was started in 2021, is now adopted by many banks like HDFC, Kotak Mahindra, ICICI, State Bank of India. I mean, there are some of the many examples that I could think of right now. But yes, AAs that are account aggregators have received in principle approval from the RBI to operate using the standardized consent artifact released by MeitY and detailed rule book given by RBI's master circular. Significant privacy features of the consent artifact has been included, which will talk about establishing the identity of the participants, logging of consent flows, consent verification, the revocation of consent, the security standards, the purpose, limitation, the storage, the user limitation. So account aggregators will operate within the consent artifact's strict paradigm. They cannot access, view, or store the data flows between the information provider and user. They will operate similarly regulated by the Data Protection Authority and MeitY. So how will they play this critical role? So when we speak of consent, the Act sets a principle for data protection and does not prescribe guidelines for consent as of now. The role of consent manager is extremely vital and critical in standardizing that consent. Companies that can leverage this framework could have a significant advantage in complying with the requirements of the data principles, right, and increasing consumer trust. Now, consent can be of many kinds. It can be consent for sharing, and it has to be an informed and categorical consent. It has to be a consent which is linked to a purpose. The consent for withdrawal, the consent for collection, the consent for repurposing and sharing data, and also consent must be demonstrable by the data fiduciary. Standardization, accuracy and quality, consumer trust, privacy, embedded into the design are some of the features given into the structure of consent managers' working framework. Now, when we speak how companies will prepare themselves to participate with consent managers, we feel that organizing information for consent preference management is the first step. Companies should be ready to effectively process and manage data privacy subject request as the law gets enacted and has been enacted now. The compliance of the same will be taken care in coming 10 months. It will be done in a phased-wise manner, but the data subjects with regards to consent, sharing of data, the access, the retention, the deletion is extremely crucial. So having a framework is very important. The context of corporate entities will need to be determined now. The role as of data users, data providers, and with regards to data fiduciary in the context of the services will now needs to be structured in all the corporates. It has to be categorized services, and the personal data proceed against each other service could be a good starting point. One has to develop a team within the company. An entity should need to dedicate teams to understand and communicate the security standard reporting and technical requirements. From KPIs to audit trials, participants in this framework should develop KPIs and audit logs to communicate to the customers and the authority that how data has been produced annually to the customers and how it has been removed, or how they can enable transparency for them to showcase where and how the data is being used or was used or has been removed. Now, when we speak as lawyers and when we speak as public policy professionals, one of the most important part is grievance redressal mechanism. Companies will now have to and should create internal grievance unit for redressal and guidance under Data Privacy Act. So, yeah, thank you.
Perfect. So I believe consent is really a major part that plays in and out of so many roles that we have to play in our daily life. But before we end the session, there's a very essential question that I want to put up. That's what are the consequences of non-compliance with this provision of the Act?
Yeah, thank you so much, Isha, for this relevant question, because without, understanding this particular point, we would not to understand what is importance of our duties in this particular act. So this act is talking about penalty in terms of because we have already understood there are a lot of duties exactly. So this duties is regulated by this particular provision, and which start from 10,000 to the 250 CR, and it's depend on the case to case basis, and it should be decided on the basis of the which type duties has been omitted by stakeholder under this act. And we need to also understand what is adjudicatory mechanism, who is going to to address this issue. So the first would be at the organizational level, at the I'm talking about data fiduciary level through grievance redressal mechanisms. And if anyone is aggrieved by the grievance redressal mechanism of data fiduciary, he should approach to the board, data protection board. And if he is also not happy with the order of the data protection board, then he can approach to the tribunal, which would be the TD side, and final remedy lie to the Supreme Court. So right now we have understood we have two type remedy with respect to the fundamental right. Then we can invoke to the 32 or 226, and one mechanism here is this particular act exactly. So if anyone directly approach to the Supreme Court, a High Court, maybe he will be not a addressed. Maybe he will be referred to. You should go to this particular act and you exhaust your remedy. So this is very important aspect we need to understand. Thank you.
Perfect. I think that covers everything, and I'd like to thank Mr. Rajeev and Ms. Shreya for making us understand the importance of DPDP Act 2023. Now let's move on to the Q&A session. I have received a few direct message questions. I'll take those up. And in case in the meanwhile you have any other questions, feel free to share it within the group with everyone or directly to me. That's fine. So the first question that I've got is, I think you could take this up, Ms. Shreya. What is your take on GDPR?
So when we speak of GDPR, I just want to quickly give a brief number. It was brought in 2018, and GDPR since then has become the topic of conversation wherever data privacy has been spoken about. EU became the first one to bring general data protection regulation into picture, which is GDPR Act. It became the baseline for wave of new data protection legislation that has swept the globe. Many lawmakers around the world just started, copy pasting that. Many lawmakers, they thought that it is easier to just adopt something which is working well in our country. But do we know how GDPR came into picture? It was formed for Bulgaria, which is a smaller country in European Union. Now, India, with its diversity, its geographical presence, and how big a country that we are, and the kind of service that we cater to, the kind of importance we hold when we speak of South Asia, or when we even speak of global importance that we hold. It was very important for us to not follow the herd behavior, but come up with something that literally caters to our own population. Apart from that, Gartner, in 2023 did a research, and it said that 65% of the world population will have its personal data covered under modern privacy regulation. So it's not that only European Union did that. European Union started that, but we followed the entire trail, and in 2023 we've come up with our act. So yes, GDPR is important, but GDPR is important for the kind of demography it caters to. Indian demography is very different and needs customized way of approach that we are doing, and we are very optimistic with the new act that has come into picture. Yes, mutual cooperation between countries and integration of global markets are needed. We need to understand what laws the other countries are making with regards to data, and assimilation of the thought will only lead to trade expansion and service-related agreements, or when we speak of bilateral agreement and understanding between countries, so it will hold a vital importance there. So yeah, that's on GDPR.
Perfect. Thank you, Ms. Shreya. And since we are almost about to reach our hit time, I'm going to take a few other questions. Please be welcome to join in later, or you can drop us an email or just call us, and we'll be happy to address your concerns here at Areness. The next question says, if you could please take it up, Mr. Rajeev. It says, could you explain more about the bar of jurisdiction under the Act?
So yeah, bar of jurisdiction means here the Act is talking, because this Act is a special Act,
Okay.
This Act is a special Act, and it will be prevailed over the General Act. And the particular provision of this Act is talking about if anyone aggrieved with respect to the information privacy, he approaches to the civil court, the civil court will be not allowed to entertain the application. So he need to the approach to this particular act exactly. Whatever we have already discussed about, we have a educatory mechanism. They need to follow this educatory mechanism.
Perfect. Thank you, Mr. Rajeev. And I have a question to Ms. Shreya. So how do you think the new data law will be fitted as per the international standards?
Okay. So Esha, when I say we did not copy GDPR, but we did keep in mind the global best practices. When I read the DPDP Act, it clearly had a resemblance, and when we speak of certain organizations like OECD and UNCTAD for that matter, so the law to protect data privacy is important. We are aware about it. So there are certain standards set up by organizations like Organization for Economic Cooperation and Development, which gave its guidance with regards to following, where it outlines the data privacy, how it should be recognized as a global minimum standard for privacy and data protection, how it forms a solid foundation for building effective protection and trust for individuals, developing common international approaches to transport data flows. The OECD rule book, which we also try to incorporate, keeping in mind international standard, helped us promote a holistic approach to privacy and data protection. And in continuity to that, we are working with countries and experts to widen the scope of development to evolve data privacy guidelines in today's digital environment. It is a continuous journey, so yes, to develop and upgrade data protection law is only a way forward. But similar to that is United Nations Conference on Trade and Development, that is UNCTAD. So we really took the guidelines of these two international agencies to ensure that our act doesn't lack the global best practices. And with regards to that, more and more social and economic activities are driven in digital mode. So UNCTAD gave a very good direction on that. It says the importance of privacy and data protection is increasingly recognized when socioeconomic aspects are concerned. The collection, the use, sharing of personal information to third parties without notice or consent of consumer is not to be permitted, and legislation for data protection is necessary. In this context, 137 out of 194 countries, including India, has put in place these aspects in the legislation to secure the protection of data and privacy, and India has joined that league. So yes, we are part of the best practices. We are not copycats, but yes, we are part of the global best practices.
Yeah. Thank you, Ms. Shreya, for taking that up and giving such a brilliant explanation to my question. Since we've almost reached time, I will pick another question. It says whether the individual will also be liable for any breach under this act. If Mr. Rajeev, you could take this up.
Yes, at the outset, we have already discussed about the four stakeholder. The right, everything is governed through the right and duties forms, because we are part of the digital ecosystem. So we cannot individually liable to the data fiduciary, and the liabilities would be also lie on the data subject. So I would like to take example of in context of data breach. So in the data breach, there is one obligations if individual has some notification, some is got some sense his data has been compromised. So immediately he need to apprise this fact to board, and if he's omitting this duty, he will be also penalized, and the penalized would be I think 10,000 rupees. And in addition, he's not allowed to give a impersonation his personal information to other person. So which need to be followed by data principle.
Perfect. Thank you, Mr. Rajeev. Thank you, Ms. Shreya. I think the session was very helpful, and me being a layman, even I have learned a lot from this session, and I will be keeping my data very securely going forward. And I would also give a round of applause to Girma Pro and ARM Worldwide because they are the sponsors for today's webinar. And in case you have any legal queries, you can push them on to the number that you can see on your screen. And other than that, thank you for joining Statusphere, one of our webinar series, the first of our webinar series. And we'll see you very soon with another very interesting topic. So just stay tuned and wait for our next webinar. Thank you all for